Hi there, this is Jennifer Collins, and you have probably found this video because you are trying to study for your Arkansas real estate exam. And on there, you're going to have regulations. And what I'm going to do in this video is go over your seller or lessor agents section, which is 8.1. Your buyer or leaser agents, which is section 8.2. We're going to go over 8.3, which is dual agency. 8.4, failure to disclose agency relationship. So we're going over the first section, which is section 8 of the Arkansas Real Estate Commission regulations. And I'm going to be reading from the quick reference guide. So thank you for joining me. And I learn best by reading to myself and reading out loud. So this will be something that you can listen to on the go. So here we go. In Arkansas, these are the Real Estate Commission regulations. And so section 8. Section 8 is agency disclosure. 8.1 says this is the seller or the lessor agents. In any real estate transaction in which a licensee is acting solely as an agent for the seller or the lessor, the licensee shall disclose to a potential buyer or lessee or to the buyer's or lessee's licensed agent the licensee's agency relationship with the seller or the lessor. Such disclosure shall be made in a timely manner under the particular circumstances so as to avoid the extent possible eliciting or receiving from the prospective buyer or lessee information which would reasonably be executed to remain confidential and not disclosed to the seller or lessor, such as, for example, information concerning the real estate needs or motivations, negotiating strategies or tactics, or the financial situation of the potential buyer or lessee. Number 2, when the disclosure is made to the licensed agent of the buyer or lessee, it is that licensee's duty to convey the disclosure to the buyer or lessee in a timely manner. So they said timely manner twice. B, in all cases, disclosure shall be in writing, but may initially be made orally and reduced to writing. That's key word. At a convenient time subject to the requirements of Regulation 8.1. Evidence of the disclosure shall be maintained by the licensee. In all cases, however, such disclosure must be made before the buyer or lessee signs any document related to the transaction, such as an offer or lease or rental agreement. Okay, got it? 8.2, the buyer or the lessee agreement. Okay. In any real estate transaction in which a licensee is acting solely as agent for a buyer or lessee, the licensee shall disclose to a potential seller or lessor or the seller's or lessee's licensed agent, licensee agency relationship with the buyer or lessee. Such disclosure shall be made at the first contact with the seller, lessor, or the agent of the seller or lessor. 2. When the disclosure is made with the licensed agent of the seller or lessor, it is the licensee's duty to convey the disclosure to the seller or lessor in a timely manner. Okay. In all cases, disclosure shall be in writing, but may initially be made orally and reduced to writing at a convenient time subject to the requirements of Regulation 8.2. Evidence of the disclosure shall be maintained by the licensee. So are we seeing a pattern here? Timely manner, reduced to writing. Timely manner, reduced to writing. C, in all cases, however, such disclosure must be made before the seller or lessor signs the document related to the transaction, such an offer or lease or rental agreement. Okay? Got it? 8.3, dual agency. A licensee who represents both the seller and the buyer in a real estate transaction, or both the lessor or tenant in a real estate lease or rental transactions, shall make disclosure in a time and manner required by Regulations 8.1 and 8.2. And all parties to the transaction must have given their written consent to such dual representation prior to or at the time of execution of the agency contract. So listing contract or property management contract, lease or rental agreement, offer and acceptance contract or other real estate contract. So must be in writing. Okay. B, and notwithstanding Regulation 8.3, a licensee shall not accept a commission, rebate, profit, payment, compensation, or other valuable consideration in connection with the real estate transaction or real estate activity from any person or entity except the licensed principal broker under whom the licensee is licensed. Because if we do not, that is under 8.4, failure to disclose agency relationship, which means a licensee who fails to disclose the licensee's agency relationship in a timely manner required by these regulations shall be subject to sanctions under Section 17 of Act 690 of 1993, which is, I'll throw this in there, a $1,000 fine and a Class D felony. Okay. 8.5, fidelity and honest dealing. A, in accepting employment as an agent, a licensee pledges to protect and promote the interests of a client or clients. This obligation of absolute fidelity to the interests of the client or clients is primary, but does not relieve a licensee from the equally binding obligation of dealing honestly with all parties to the transaction. B, a licensee shall not offer or advertise property without authority, and in any offering or advertisement with the price quoted must not be other than that agreed upon with the owners as the offering price. Okay. And they're pretty serious about that. C, when acting as an agent in the sale or management of a property, a licensee shall not accept any commission, rebate, profit, payment, compensation, or other valuable consideration from any source in connection with the property without full written disclosure to the party represented by the licensee. A licensee shall not accept compensation from more than one party without full written disclosure to all parties to the transaction. Got it? All right. Thank you. That is 8.1 through 8.5 of the Arkansas State Commission Regulations, Section 8. Thank you for watching, and I'll be doing the next section later.